whether to add a clause on subsistence allowance. Again, subsistence allowance, it is discussed in two legislations. One is the standing orders, right? And some of the states, they have a specific legislation called Subsistence Allowance Act. Tamil Nadu, Kerala, and West Bengal, they have a specific legislation. They talk about subsistence allowance. But even though these legislations talk about this, again, you can bring this clause in the appointment order, right? What will happen is otherwise, during the suspension period, you may not be able to pay 50% of wages. Instead, you may have to pay 100% of wages. So it is better. So because the Subsistence Allowance Act or Industrial Employment Standing Orders Act may not be applicable to all the employees again. So for the other persons, if you have this clause, then it is better. Otherwise, for the other persons, if you happen to suspend them pending inquiry, then I don't think you will have the luxury of paying only 50% or 70%. You may have to pay 100%, right, from the day one onwards. So it is better you have this clause incorporated in the appointment order. Is notice period on either side mandatory? Yes, again you bring it, right? So normally it is 1 month, right? Normally it is 1 month, and of course again some of the state specific shops and establishments have prescribed the notice period once a person completes 6 months or a person completes 1 year, right? Otherwise also it is better you can make a mention. So for the workers category, it could be 1 month, but those who are not falling under the definition of the term workers, you can keep it as 2 months or 3 months. Say for managers, it is possible because they cannot invoke ID Act because they are not workers. They can only approach the civil court, right? But for them, definitely you can invoke. But if you are expecting the individual employee to give notice for 3 months, then on your part also as an employer, when you want to terminate the services, say particularly the non-workmen, you may have to give the same period of notice. That is 3 months. You cannot have different period, right? For one party it is 3 months, and another party 1 month. No, it is not possible. It may not be considered valid. I'll move on. So yeah, I think this is just to it kind of consolidation. We discussed all these points. So the position or status, again I would say it is mandatory. It is a contractual condition. So it emanates out of, when I say contractual, it emanates out of the contract. So I would say it is mandatory, though there is some influence from the Standing Orders Act. Right. Similarly, place of posting mandatory, salary post mandatory, period of probation, retirement age, right to transfer. Definitely, there will be influence on these classes from the standing orders, certified standing orders or model standing orders. Yet, please mention it in the appointment order. And the right to provide training, right to depute a person to other companies or to other places, right to subject an employee to medical examination, and abandonment, right, or the automatic termination class. Please bring in all these classes. That is the reason I have mentioned as mandatory. And on the second column, I think it is contractual conditions only, but it is preferable, I would say. So to whom this person is reportable, please make a mention about this. Even if you do not mention it in the appointment order, maybe you may have to give a separate order, right? Because that person must know to whom he is reportable, right? Keeping management informed. So whatever information about which the person comes across during his employment, so he has to necessarily inform the management about it. His supervisors, right? You can bring a class about that also. Then to maintain office timing, punctuality, and whole devoted time only to this employment, that is whole time employment. Then the mode in which any communication, top-down communication will be made, whether it is through notice board or through some handouts, how it will be made normally, that can also be indicated to the individual. Leave eligibility of the individual and procedure to be followed, and preventing searching for another job while in employment, right? Then general advice to follow the rules and regulations of the establishment, which are currently in vogue or which will be introduced on a later date. So these are all preferable, I would say. On the third column, these are all non-contractual conditions. So you can take a call. Working hours, restricted. Definitely there will be, if it is a factory, then there will be some guidance from the factory side, right? But it is not necessary you have to mention it, but it is your choice. Working hours, rest interval, holidays, all those things, weekly holidays or the national holidays, festival holidays, and the employer's contribution towards PF, ESI. It is not mandatory, but you can take a call whether to mention or not. Similarly, bonus payment, gratuity payment, leave entitlement, These are all by operation of the respective legislations, weekly holidays, national festival holidays, maternity benefits, etc. Even though you are not mentioning it, the person will be entitled. Otherwise, if they are eligible, right? I'll move on. So finally, this legality. So the contract, again we discuss. So the purpose for which the person employed shall be legally valid. It cannot be a illegal purpose. And the impossibility of performance, again impossibility should be avoided, right? So it should be reasonable. That person must be able to perform the task.